Yes, ma'am.
Very cognizant of the time, and I'll be very brief. My lords have heard very lengthy arguments, so I want to start by a quote by the Soviet premier at the time, Nikita Khrushchev. And what he said was very interesting. He said, "You Indians are a remarkable people. How did you manage to liquidate the princely states without liquidating the princess?" So, my lords, I want to start by saying that in fact it was the constitution writing was a remarkable exercise, and the coming together of the Indian Union and the Indian Federation was a remarkable exercise. And it's in that context, and even the Soviet premier of the time, because it was not common practice, these nations were being born. And so, my lords, I started with that. To come to my first point, I have three quick points, and I'll try and make them very quickly. The first is about the concept of federalism as it operates in the context of India. And to that extent, my lords, I want to say that yes, at one level, Jammu and Kashmir is unique, but at the other level, it is also part of a federal union as federations are understood. And I want to take the example of the United States because it's the first democratic country, federal country that comes to mind. And my lords, in fact, the US National Constitution is a very thin text. My lord knows that. It only has 7 articles supplemented by a total of 27 amendments. And it is importantly Article 1, Section 8 of the US Constitution that enumerates the specific powers taken over by the Congress and the federal level of the government, leaving all other spheres of autonomy to the states by default. This is the 10th Amendment, which expressly defines the status. So, my lords, my point is that federations, as we understand, can have a variety of permutations and combinations. There is no one kind of a typical state, even within federations, that can be envisaged. And my lords, my point then comes to Jammu and Kashmir and how do we envisage states within the Indian Federal Union. My lords, there are various ways. One is we have a union territory. So, in a way, it's state minus minus. Then we have something, my lords have dealt with it extensively in the GNCTD case, that it is a UT, but with legislative powers, my lords. And so and then you have something like Jammu and Kashmir, my lords, which is a state plus with its own constitution. And so a constituent assembly was formed and a constitution was given. So, my lords, we must see that there are various permutations and combinations, and it is unique, but also a normal part of federalism. And my lords, there is a very important concept within federalism. One is holding together, and the other, my lords, is coming together. So and my main proposition is that while most of the Indian Union represents what has been called a holding together type of federation, where a multicultural polity with strong unitary features constitutionally splits autonomy between the Union and its regions to hold those regions together. However, Jammu and Kashmir represents much more a coming together federation, my lords, where previously sovereign polities pool their sovereignties and resources to come together and form a more secure and long-standing union. So it is within that we are envisaging the federalism that is envisaged for JNK. My lords, I have said, I've said various things in my note, it supplements it, but I'll quickly then come to my second point. And my second point is about the fact that when we look at Article 368, I'm saying let's forget Article 370 for a little while and the constitutional amending provision that 373 provides. Let's just look at Article 368, which is the constitutional amending power. Now, by their very nature, a constitutional amending power is far stricter than the normal legislative powers that even the parliament has. My lord, so therefore there are many checks and balances that Article 368 envisages that is not envisaged in the general legislative powers that are exercised either by state legislatures or by the parliament. So my lords, therefore, when we are reading 370, so what is my point? My point is that therefore, when we are reading 370, it must be a very strict interpretation of what can or cannot be done. And therefore, when we are reading 370, it cannot be that in a casual manner, we are substituting one authority with another, as has happened in the constitutional orders that have been promulgated. My lords, I then come to, in fact, my Lord Chief Justice's question while I'm answering this. And my lords have read this article, I don't know how many times, 370, but may I please urge you to read it once more with me. Please, my lords, if you can come to Article 370 once more, because my lords have asked a very important question from all of us on this side, and that is that how do we read 2 and 3 and the Constituent Assembly part in it? And there's a clear answer for that. My lords, if we read, sorry. My lords, I apologize. Just, yes, if my lords can read para 2 with me once more, there's a clear answer. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1, or in second proviso to subclause D of that clause be given before the Constituent Assembly, for the purpose of framing the constitution of the state is convened, it shall be placed before such assembly for such decision as it may be taken thereon. My lords, I'm making a simple point that this was a transitional provision because of the fact that it uses the word before such assembly. It only provided a protection to place before the Constituent Assembly when a Constituent Assembly had not been formed. After that, the power that is vested in 2 was subsumed by 1. And therefore, it answers my lord's questions that are the subsequent presidential orders legal? Yes, they are, because they are not under exercise of power under 2, but under 1. And my concomitant point with that, my lords, is very respectfully. So our constituent, assembly makers, or our constitution makers were aware that at some point in time, the Constituent Assembly of J&K would have served its purpose and would no longer be there. And for that particular purpose, they had given that how can you make changes, and that was provided under 1, right, my lord? So therefore, they were equally aware that the Constituent Assembly would cease to be in power. Yeah. Yes, only before. My lord, I'm sorry if I'm moving very quickly, but I'm just cognizant of the time. My lord, so my essential point here is that the constitution makers were aware of the fact that the Constituent Assembly would finish its function and then no longer exist. And therefore, for making any changes, they had provided for the via 1. But for the abrogation, they only left it to the Constituent Assembly. My lords, there is no other way to reconcile the two. My lords, otherwise, how do we say that the presidential orders, and that's a question that has been falling from my lordships, I have seen very much from day 1. And the only way to look at it is that clause 2 was a transitional provision, was only provided for, and my lords, there is logic in it. Because of the fact that before the Constituent Assembly was formed, the government would have needed concurrence because it was transitional. We did not know how exactly they represented, whether they represented the will of the people, etc. or not. And then after that, there was an assumption that the government of the day would be representing the will of the people. And so, at least with respect to certain decisions, at least with respect to making certain other parts of the the constitution applicable to the state. However, equally, my lords, if we take that interpretation, then we'll have to set in time the Constituent Assembly and its power and the recommendation being necessary for the abrogation. My lords, because then it will reconcile. And my lords, just one very quick last point is the question, my lords, that even if we left everything aside, my lords, what happened on 5th and 6th of August 2009, and my lords are a constitutional court. My lords, 3 former chief ministers were in detention. And these are all facts, my lords. 3 former chief ministers, most of your legislative assembly. My lords, the will of the people is exercised by the legislative assembly, were in some form of detention or the other, either under the Public Safety Act or, my lords, under 107, 105. It's laughable. In Delhi, if entire polity and all of the politicians who have actually supported you, who've been legislative members, are put in this manner. And therefore, I come to my last but very important argument that this is malice in law, because what this demonstrates, my lords, and how do we determine malice in law? By the actions surrounding the abrogation itself. And my lords, I'll just read very quickly, because I don't want to burden my lords with reading anything at this stage. But malice in law is a very well settled principle. I'll just read it. And it has been held by this honorable court as follows. This court has consistently held that the state is under an obligation to act fairly without ill will or malice in fact or in law. Where malice is attributed to the state, and my lords, we are doing that, it can never be a case of personal ill will or spite on the part of the state. Legal malice or malice in law means something done without lawful excuse. It is a deliberate act in disregard to the rights of
read your submission below the quotation, because that will help us.
Lords, it's there.
The abrogation of Article 317.
Yes.
Was effected secretly. You can read that, those 2 sentences there.
Yes, my lords. The abrogation of Article 370 was effected secretly, unilaterally, and coercively. Not only was the democratic process disregarded, but also the people and their leaders were kept in the dark, prevented from communicating with others, my lords, and even detained till the Union of India could issue them a fait accompli.